Yeah, right. All right, good afternoon, everyone. We're going to get started. My name is Daniel Castro. I'm Vice President of the Information Technology and Innovation Foundation, or ITIF. If you don't know ITIF, we're a nonprofit, nonpartisan think tank working at the intersection of technology and innovation and policy. I'd like to welcome you to today's event, Using Technology to Make Real Estate More Competitive. Before we begin, just two notes on logistics. First, the event is being recorded. The event is also being webcast today, so thanks to those of you who are joining us online. If you're in the room, we're going to have time for audience questions at the end of the panel. If you're watching online, you can also submit questions on Twitter. We're using the hashtag ITIFRealestate. It's on the webpage, and I'll make an announcement about that again. But again, we welcome those questions, and we'll be asking that of the panel later. All right, so the question we want to explore today is, fundamentally, why hasn't technology created greater disruption in real estate? So, if you look back, in most industries, the internet's had a profound impact on companies and business models. So, this is Blockbuster being replaced by Netflix, travel agents really disappearing and everyone using Expedia now, taxis, of course, being replaced by Uber and Lyft. But this type of disruption, I think, has largely been absent from the real estate industry. There's certainly been changes and new players, kind of most notably the Zillows and the Redfins, but the impact here has been significantly smaller, and the traditional broker model is still thriving. Now, the fact that the brokers are still there isn't necessarily a bad thing. In the end, it doesn't really matter which business model wins, but the best business model can only win if there's competition. And the reason, of course, the competition matters here is because competition is what leads to the efficiency and cost savings for consumers that we see in so many different industries. And here, I think, is where there's a more serious indictment of the real estate industry, because transaction costs for residential real estate are still substantial, with many paying these relatively high fixed commissions that have been standard in the industry for for decades. Just this week, there was a study that came out. It was printed in the USA Today that showed the average homeowner spends nearly $20,000 selling a home, with the bulk of it being commissions, but also expenses such as transfer taxes, filing fees, and title insurance. And of course, these commissions vary considerably by the market. San Jose was the highest in this study, about $70K. DC was around $23,000 and $15,000 in Baltimore. So today, we want to discuss how policymakers and industry can work together to use technology to make home buying and selling better for consumers. We have a really fantastic panel for this event. I want to thank all of them for joining us today. Starting right here on my left, Ralph Holman is the Associate General Counsel of the National Association of Realtors. He has over 40 years of experience in the field. Actually, I guess you're former Associate General Counsel. This will be your last act.
We'll see.
We'll see. But now you can tell us all the things you wanted to say before that. Now that you're retired, you can.
I'm still pretty close to it, but I'll tell you the truth.
All right. Continuing on to his left, Ben Clark, broker and consultant. He has lots of experience advising companies on innovations in the real estate sector, including in the past with eRealty, Zillow, USAA, and Quicken Loans, Home Scouting. So thank you. To his left is Jessica Drake, an attorney in the FTC's Bureau of Competition, where she led and participated in numerous investigations relating to real estate data software and internet platforms. She's also in charge of the FTC workshop that's joint with the Department of Justice that was just announced today. So thank you for being here, and thank you for that work as well.
Thanks for the plug.
And we'll tweet out that link, and we'll be talking more about that in a minute. Continuing on, we have David Culley, who's an antitrust attorney at Holland & Knight. He has extensive antitrust experience. He joined the firm after serving as chief of the Litigation 3 section of the U.S. Department of Justice's Antitrust Division. And it was there where he led the enforcement efforts in real estate, residential real estate, in particular the litigation against the National Association of Realtors that established that real estate brokers could not use their control of MLS data to impede competition. And finally, Brian Larson, an associate professor of law at Texas A&M University School of Law. He's also formerly led Larson Skinner and still of counsel there, a law firm that focused on providing legal counsel to real estate, multiple listing services, and trade associations. Also in 2005, the Council of Multiple Listing Services inducted Dr. Larson into its MLS Hall of Fame. That's a great trivia question for trivia nights.
Except it was 2015.
It's 2015. Did I say 2005?
Yeah, you would have lost on Jeopardy. So.
2015. And the harder question is, who are the other 4 people who have been inducted in?
I know 3 of them. Pat Bybee, who was an MLS exec, who was killed in a car accident. Peter Shuttleworth, an MLS exec who retired after many years. Ann Bailey has since been inducted. She was a consultant in the business, and the last person, I don't actually know that person. I saw that name when I got the award, and I have no idea who that person is.
Okay. Well, thanks to all of you for being here. And let's start with, I want to kind of go back in time and then come back to the present. So David, let me start with you. 10 to 15 years ago, actually, I think I'll start with you, because I want to talk about some of the original companies in this space first. So let's go back 10 to 15 years. What were the challenges that these early internet startups were facing in the real estate sector? What were they trying to do differently?
Well, at first it wasn't a challenge at all, because addresses for homes for sale actually were not even on the internet. And we had a group of technologists that came to a group of brokers who were very experienced in the business and said, how can we do this better? George Kettle, actually just a grandfather to the business, had 6,000 agents, 450 offices in the DC area. He invested in our company, and we built an internet service delivery mechanism for professional services. You acknowledged agency at the state level before you saw MLS data. We maintained a record of that acknowledgement, and then displayed an electronic version of the customer printout, which was available in the offices of every real estate agent. And NAR did an incredible job reviewing what it was that we built and what we were doing and how we were delivering it. And over some time, we created a joint marketing agreement with a well-known portal. And when you could look at your stock quotes and your stock portfolio, you could, through also that encrypted password, see homes for sale, because we were an electronic service delivery for our clients. You could see the same information. And when real estate information became viewed on a very popular portal, we had a joint marketing agreement. There was an upswell of competitors who saw that as an unfair competitive advantage. And we saw it as a differentiated competitive advantage, and we liked all the attention, and it was great for our company, but it did begin to impede what we had was an internet-based delivery of services. And marketing was just a very small part of a very deep, integrated, interoperable set of data that came from MLS or originated from us to serve our clients. And then other things happened that lawyers deal with, and being the only non-lawyer up here, I should probably stop now, because what happened after that, I think Dave could probably help with. That's
sure, and Ralph, let me bring you in on this too first. You were obviously in the industry for the internet, and you kind of saw NAR's response and everything that led up past that. What were people talking about then when they saw this? What were they wanting to do? What were they not wanting to do? What was the conversation like?
Well, initially, I think the concern was whether or not brokers could take listing from the MLS. They got listings of other brokers and put them on the internet. And they had a problem in doing that because in most states, I think virtually every state, the law prohibits brokers from advertising other brokers' listings. But we clearly perceived that there was an interest in allowing brokers to use this new thing, at least to them, called websites, to promote not only their listings but the listings of other brokers. So we created rules that facilitated the ability of brokers to advertise the listings of other brokers on their websites. They're then called the IDD, Internet Data Display, now called the IDX rules, which created a presumption of consent to display the listings of other brokers derived from the MLS on those websites.
Yeah.
And so that led to sort of an explosion of brokers having the opportunity to display all the listings in the MLS on their marketing websites, publicly available.
Do you think, we'll just kind of jump into this, I mean, there's obviously the consent agreement we'll talk about in a second, but do you think NAR did anything wrong that led to that? Or would you say you guys were, I don't know what you would say.
I think we created the platform by which brokers could be authorized through a presumption of consent, which they could withdraw if they choose to, and virtually none did, but a few did, to advertise the listings of other brokers. So I think that was exactly the right thing to do. We empowered brokers to be more, to be able to advertise listings not only of themselves, but of other brokers to a wider audience, giving those listings more broad exposure.
Dave, let me bring you in. So why did DOJ step in?
So we stepped in because there were people who were not satisfied with using just the IDX data that NAR's IDD or IDX policy allowed them to use. And as Ralph mentioned, in many markets, there were a lot of listings available through IDX, but in some markets, a lot of brokers had opted out of IDX, and the amount of listings that were available to a broker who wanted just to provide listings to their client over the internet in some markets was very low at that time. I think that's changed since then. So brokers like eRealty, Ben's company, and Zip Realty had developed a business model where they were allow registrants on their websites to search the entire MLS listings database and to allow consumers to educate themselves about what was on the market and to only interact directly with the broker at the time at which they're well educated, ready to get in a car and drive. So NAR's initial position on this was that this was okay. This is different from IDX. The delivery, NAR's rules didn't discriminate in the method in which brokers delivered listings to customers. That delivery over the internet was the same as mail, hand delivery, carrier pigeon, however they felt like doing it. But the business model was met with some hostility in some markets, including, for instance, in Austin, Texas, where the MLS tried to shut down eRealty, and they only relented when a federal judge said what NAR said, which was that the delivery of listings over the internet was equivalent to all other methods of delivery, and NAR couldn't discriminate. So the DOJ got involved when broker hostility to this business model sort of overcame NAR's initial position. And in 2002, 2003, NAR had a legislative initiative to try to evaluate whether special rules needed to be adopted for this. There was industry pressure based on the idea expressed by some large brokerage companies that the fear was that big internet companies that were so good at internet marketing, they would beat brokers to potential buyers using listings as bait was the term, and then resell those listings to brokers. So brokers that were hating this. NAR's legislative process culminated in May 2003 with the adoption of a vow policy that singled out.
Can you define that for? We have a mixed audience here.
I apologize. So in the course of this, NAR began calling this brokerage business model that eRealty and Zip Realty use of interacting with consumers over the internet a virtual office website, a VOW. And this VOW policy singled out brokers who used virtual office websites for discriminatory treatment. Principally, the principal tool was to allow all of their brokers in the MLS, all of their competitors, to say, you're not allowed to show my listings over on your website. And if you want to show them to consumers, you have to use the old ways of doing it. And for the DOJ, this was an agreement among incumbent brokers through their MLS to impede a new innovative form of competition that consumers liked and that allowed brokers to operate more efficiently, reduce their costs, and in some instances give discounts to consumers.
Can I just add to that? So, but it's important to recognize there were the IDX rules, which allowed brokers to advertise listings, made generally available to the public, and then, as Dave said, in a few markets, some brokers opted out, and there were brokers in those markets, and others as well said, no, we want to actually do business. We want to conduct brokerage business over the internet. We don't want to just advertise listings. We want to conduct brokerage. And we're going to create a website that's called, and we didn't coin the term, brokers did. We adopted it because it made sense, virtual office website. We want to do that as well. And, our MLS policymakers said, that makes sense, but we should create some sort of, structure, not as a way to impede brokers doing that, but just so that they understood what was permitted and not what permitted, because, this MLS is an entity that forms cooperative relationships between competitors to do business. It's an activity which is really not common in other industries. I can't think of a single one where two competitors come together to share and engage in a relationship to do business, which, you know, benefits both of them. So we created these virtual office website rules, which, as Dave said, you know, created some structure, said you can do it, you can use all the data. In fact, like the IDX rules, we required MLSs to provide the electronic information that would empower them to, in the case of IDX, advertise listings, in the case of VOWs, to do brokerage over the internet. You know, we included in those VOW rules a feature Dave alluded to, the ability of brokers to unilaterally say, no, I'll share my listings with you and I'll offer to engage in a cooperative transaction with you, but I don't want to also empower you to gain a competitive advantage over me by putting your listings on your virtual office website. Now, we thought, and we still think, that that's unilateral conduct not precluded by the antitrust laws. The department disagreed. Again, we have a principal disagreement. We almost went to trial. You know, that's why you have judges in trials to sort those things out. Fortunately, we were able to avert that. But they're two fundamentally different concepts.
Mm-hmm. Let me ask Ben to come in here, because I think your explanation to the average listener would be, you know, there were these rules, they made sense at the time to set a fair playing field between the different parties, which have different interests. I think Ben's probably over there thinking, well, we're trying to start a new business here, and all the people with power were keeping us out from the listings. I'd like to hear kind of your reaction to.
Well, one point to remember, it's a great question, Daniel. One point to remember is that the withholding of listings to an internet-based brokerage was proposed and implemented to be done in a way without the seller's consent. So when you were listing your home with a broker and you believed that that broker, whoever it was that was a member of the MLS, was going to do everything they could to get the broadest audience for your home to get it sold, they could go back to the office, and the agent that's curating the information that ultimately becomes a listing that goes into the MLS with a variety of models around the country, big and small. It might pass into ownership, it might not. We know who owns this kind of data as part of it. But one important point is that the uninformed seller about where their listing goes was the biggest problem for us. Did the sellers, were they aware that some homes for sale would not be seen, and that seller wouldn't even know that their listing didn't get broad distribution? And we were focused on the consumer, and we called them today's consumer. It was an exciting time then, and it's even more exciting today with ways of authentication and the way our phones work to connect to the internet.
Right.
Yeah, Daniel, I wanted to mention that I was managing an MLS at the time much of this was unfolding, and the first VOW that I saw was in 1997. So these were not brand new in 2002 when NAR was legislating, as you said, regarding them. If it had been legislation, you wouldn't have been able to sue them over it, you know. That when they were making their policy decisions, and here was the challenge, you had MLSs like ours which said, okay, these are equivalent as long as the specific risks associated with online brokerage are addressed. You need to get someone to register in order to use this database so we know you can establish a brokerage relationship with them. We had other kinds of restrictions that were specifically tailored to the technology involved, but we thought kept the door open for competition. There were other MLSs that said, we don't think we understand this, we don't like it, we don't want to allow it, and they weren't allowing it. So NAR, first with Lori Janik, I think their general counsel, writing a letter sometime maybe at the end of 2001, saying this is what they are and they're actually okay. And then later saying, okay, well, our MLSs, and there were many more of them then than there are now, our MLSs are confused. So let's provide them some guidance about how they can regulate these things to the extent that's required by broker interests and the MLS's interests without violating the antitrust laws. Now, Ralph maybe can't say this because he still sort of works for NAR, but I think NAR made a mistake in terms of adopting that selective opt-out. I said so at the time. There were others who said so at the time. And I think that largely precipitated the dispute between the DOJ and NAR. If you set that issue aside, the VOW policy we have now looks quite a lot like what NAR initially proposed. Right? So it wasn't that NAR had some kind of radical desire to disenfranchise technology-based brokers. It's that they were trying to clearly make them enfranchised, clearly make them capable of doing what they wanted. And I often complain about NAR, but not on that issue.
And it turns out that a lot of those VOW rules were about establishing the reality that brokers operating claim to be, which is they were engaging in brokerage. So the rules required that a broker engage with a consumer over the internet in the same way as he or she would do in the office in terms of making agency disclosures and things like that. As it turns out, there really aren't many VOWs that operate now. There never were a lot of them. I think brokers would tell us that they didn't want to operate a VOW, which required a consumer to, pick a username and a password and all that, go through all that rigmarole, because they wanted to give access to consumers' listings right away without, inhibiting their ability to see the listings right away. So a lot of brokers found that that kind of model, that kind of website, just wasn't in their interest. And I think that's true today. There just aren't that many websites that brokers operate that comply with all those VOW requirements where they're really engaging in brokerage. Instead, brokers seem to prefer using the IDX method.
David, let me bring you in again, and also just kind of bring the question a little forward. So the settlement's expiring. What does that mean for industry? What does it mean for consumers? What does it mean for the different stakeholders?
So the settlement, so the case litigated for a few years. So first of all, the suggestion, and I don't mean to relitigate old battles, but the suggestion that there was only a small difference between the NAR's VOW policy and what we ended up with through the settlement was very small. Was not really ever. It took 2 years of intense litigation and up to the eve of trial to achieve that. But so the settlement enshrined the principle of parity that NAR's affiliated MLSs had to treat brokers who wanted to operate VOWs just like all other brokers. And to effectuate that, there was a requirement that NAR's affiliated MLSs had to provide a data feed to brokers to be able to operate a VOW. The settlement DOJ cases and FTC cases that settle have end with a consent decree that is a court order. So the effect was for 10 years if NAR violated or if its MLSs violated this parity principle, the DOJ could go to court and ask a judge overseeing the case to order them to comply. So the consent decree is expiring this November. After its expiration, there will no longer be NAR and its MLSs will no longer be under the threat of being brought into court if they break the rules. Whether that's MLSs will regard that to be shackles being removed from them and they'll do all kinds of things that they had wished that they could do remains to be seen. NAR certainly has said that it has no intention of changing its virtual office website rules in a way they're going to harm competition and frankly the world has changed since then, so that the threat of brokers using the internet to try to get a competitive advantage today is probably not that much of a threat. It's sort of an accepted part of the delivery of real estate services today. And so maybe the likely effect of the expiration of the decree is not going to be monumental. I guess as I look at the case, its significance is less in how it protected a particular business model that, as Ralph points out, some brokers are not interested in pursuing, and more in what it showed about how brokers that perceive a threat might act collectively to try to counteract that threat. And I think that so what are the threats today that brokers might try to act collectively to address? And you see things like is upstream. Seems like a solution in search of a problem, and is that something that I wonder? If I had my DOJ hat on and was thinking about this, I might think about, well, what's that all about? Why is that happening? Is that something out there to address a threat in the industry? So
Thanks. Yeah, and Jess, let me bring you in too. Obviously, the workshop was announced today with DOJ and FTC. They'll be June 6th. June 5th. So what kind of questions are you thinking about? I mean, I would guess there is some linkage to the expiration of the settlement. There's also, the DOJ report that had been done on competition in the real estate sector that's now about 10 years old. What types of questions are you thinking about, and what do you think is important for consumers to be aware of?
Sure. So I'll start by saying, just to build on what David was saying, I think of the consent decrees, both the DOJ consent decree and the various consent decrees that the FTC entered into with MLSs as essentially just restoring compliance of these various obligated parties with the antitrust laws. And so the expiration of the consent decree doesn't change the efficacy or activeness of the antitrust laws, and so we would continue to look at practices post-expiration of any consent decree for whether they're consistent with the antitrust laws. With respect to the workshop, I think we're very much interested in exploring, as David said, sort of what the industry looks like now, and what are the various ways in which you might see competition changing in light of the internet's increasing role in real estate transactions. So we want to understand, with a fresh look at the industry today, what is the availability of listings information to consumers, how complete is it, how accurate is it, and to the extent that there are limitations on consumers' ability to access up-to-date listings information, where are those coming from? Are they coming from industry agreement and potentially conduct that might be concerning under the antitrust laws? Are they coming from some other origin? I think there are a lot of difficulties inherent in maintaining up-to-date, publicly accessible listings databases. It's very localized information. It's extremely dynamic, and of course, there are various stakeholders that have interests in where that information is shared. So you may have sellers who want their listings to be as widely disclosed as possible. You may have brokers who are interested in trying to ensure that they have the best shot at selling a property. So we want to understand sort of what limitations there are on accessibility of listings information, how the rise of internet platforms sharing that information has changed the industry, if at all, and what competition in the brokerage industry looks like going forward.
Thanks. Brian, I'll come back in a second. Brian, I want to ask you to comment a little bit, since you haven't had a chance to react. How the MLS has changed over the same period of time. It's not just the technology that's changed and the real estate, but also how the MLS changed. And again, we have, I think, a mixed audience here. So maybe you can also just take a minute to explain a little bit more about what exactly the MLS system is, all the different MLSs, how that kind of system has been evolving over time. And I don't think you're advising the clients to now that the DOJ's consent decree is gone, what can we do to exploit it? But how are things changing now? What's the reality look like now?
Well, so multiple listing services started in principle probably about 100 years ago, when real estate brokers who had listings realized that it made sense for them to get together, have a meeting with other real estate brokers who had listings, and see what each had for sale, because they also both had buyers. So these were often called real estate exchanges. And it was probably not until the 1970s that the multiple listing services took the form they have today, which is where by putting a listing into this multiple listing service database, one broker is saying to all the other brokers in the system, if you sell my listing, if you bring a buyer to this transaction and you bring this transaction to closing, I will pay you X% of the sale price, or I will pay you Y dollars, whatever. They can express it either way. So it's an offer to enter into unilateral contract in lawyerly terms, which everyone up here I think understands. And Ben, I think even not being a lawyer, understands it quite well, because he's been in the business for a long time. So multiple listing services at that time, I have a punch card that came out from an MLS on the date of my birth in 1966. And when a new listing came on the market, the MLS would print them out on mimeographs and distribute them to all the brokers. And then brokers, when they had a buyer, they had to find a matching listing in the punch card box. And then we had MLS books, and in the 1980s, generally, it was somewhat earlier, we started having it on computers, but it was a very sort of closed, tight computer system, not like what we see on the internet now. By the end of the 1990s, MLSs were operating their internal services, their stuff for brokers on the internet, and they were struggling with issues like, how do we make listing data available? At about the time that the VOW policy issues were warming up, we had the IDX policy. Our MLS was kind of a pioneer in terms of structuring the policies for IDX. And the idea was that we wanted to make it possible for brokers to interact with consumers online, just what Ralph was saying. But there were also these other options, right? So we had Realtor.com, which is a National Association of Realtors property that advertised listings online. It's not operated by NAR anymore, although NAR owns that domain name. It's operated by Move Inc., which belongs to News Corp. So Realtor.com was the show nationally for listings at the time, and there really wasn't anyone else. And even a player as big as Microsoft, who started its Home Advisor website, not the Home Advisor you see advertised now, but an older version of it, They weren't able to break in part because Realtor.com offered lots of incentives for MLSs not to provide data to other folks. So this is about the turn of the century. 2007 was a really weird time, though. The world changed in a lot of ways. One is that this company called 3Wide came up with something called ListHub. And this was meant to be a listings distribution system where the MLS could go to ListHub and say, here are our listings, make them available to national portals. And there was an explosion. In fact, Zillow could not be what it is today if it had not been able to get data from ListHub for 7 or 8 years before that relationship broke down. Trulia would not be where it is today. A great many listings websites would not have inventory. And so that was an initiative from within the industry. And the MLSs kind of overnight went from saying, oh, we're not so sure about sharing data, to saying, data? You want data? We got data. So they were pushing it out kind of willy-nilly. I think there's been a slight retrenchment from that because not all the MLSs, I was just looking back recently at a white paper I wrote back in 2008 saying to MLSs, hey, think about some of the issues associated with pushing listing data out. If you don't know how it's going to be displayed, you don't know what kind of risks it poses for the brokers. And so now I think MLSs have come back to look at it and say, if we're going to put the data out, we want to make sure we're not putting it out in a way that puts brokers at risk in terms of license law requirements, advertising requirements, et cetera. But what the MLSs don't do now is they don't say to brokers, you can't send your listings where we won't send them, right? So if the MLS sends the listings out to Zillow, for instance, the listing broker can say no. And if the MLS doesn't send listings out to Zillow, the listing broker can do it on her own. And a great many brokerage firms have over the years. Franchises do it on behalf of their brokerage firms. There are other services that will do it on behalf of them. So the way I would describe it today, I think there's a kind of the story of the industry now. There was a court case in Michigan just a couple weeks ago, an antitrust case involving RealComp 2 again. This time they won. And the judge said, data and choices breed competition. And he said that in praise of MLSs as a concept, not as a nag against the MLS. And what we have now is a situation where if you want listing data, if you're a consumer, every MLS out there has got at least 2 access points where you can get almost all of it, if not all of it. Most of them have dozens, and some have thousands. The Bright MLS here in the DC area has 15,000 IDX sites. And there are hardly any listings that don't appear on those IDX sites. So practically speaking, the data is everywhere. Nobody's really seriously arguing that consumers can't get access to listing data right now.
Well, see, I hear the opposite on that, and that's, I mean, I think that's one of the core questions here. I mean, so we wrote a paper that obviously, you know, is one of the reasons we're so interested in this. It was about, you know, it's titled Blocked, how, you know, different intermediaries are limiting access to data. And, you know, when I talk to, for example, tech developers in this space, you know, they say there's, you know, 2 big challenges at least. One, you know, when they want to get access to data. So, you know, if they're a developer and they're trying to, you know, build the next new app that will, you know, revolutionize real estate, their challenge is, one, getting access to the data because it's not standardized across all the different MLSs, of which there's what, like 700 plus, 800 plus.
700.
And second is actually getting physical access to that data. Not even, you know, if they have the data, there's a question of the standards. The second is actually getting access to that data, where they say, you know, this sometimes requires, you know, either being a member if you're going to be a broker, which requires a whole other set of red tape, or you know, you're a technology partner, and that requires an application process again through every single one of these. It involves, you know, sitting on someone's desk. A lot of these MLSs are small. They're not, you know, it's not like it's this, you know, advanced organization that's quickly responding at the speed of, you know, technology development.
Can I help with that, Daniel?
Yeah. So I want to put it.
Yes.
Let me put it to the entire panel, you know, because I'm hearing something very different than.
Right. Well, since you're setting it up in contrast to what I said, I mean, the fact is that there are probably 700 some MLSs out there. Nobody really knows exactly how many there are because what counts as an MLS varies depending on how you're counting. 600 of some of them are compliant according to the Real Estate Standards Organization with the RISO data dictionary, right, which is the big standard. 400 of them are compliant with the RISO API standard, okay, according to the standards organization that's required to certify them. So as far as standards, it's hard for me to understand why companies that are doing their research are having trouble, especially given the fact that you need 133 MLSs or so in order to cover 80% of the market in the United States. So, for instance, in your white paper, you talk about $15 million to acquire listing data. Well, that would be stupid because you'd be acquiring it from a bunch of places you don't need it from for the most part. The real price is probably more like $2 million. And I can't think of an industry where you can set up a business in all 50 states with inventory from all 50 states for under $2 million. It's a little hard. Again, I think you're getting a story from folks who are frustrated, and it is frustrating. You're describing MLSs as intermediaries who are blocking them, but the fact is if the MLS wasn't there, there wouldn't be any intermediaries. They'd be going to individual brokers, and there are 200,000 or more of them. Or they're going to go to 4 million consumers. How are they going to get that data? I mean,
I want to put a pin in that and come back to it. Let me give everyone a chance to respond first.
Yeah, so let me just bring up one important fact is that data about homes starts with our taxing authority. There are several hundred fields. CoreLogic actually collects 750 fields of information regarding each individual taxable parcel in the U.S. To say that Zillow wouldn't be around without 7 years of list hub data is to say that that somehow there was a dependency on data that's intended for marketing and merchandising of listings is somehow the core asset for innovators to leverage for brokerages, licensees to deliver the services for which they have a duty under the state law, whether general agency or fiduciary agency, to deliver those services with the broadest spectrum of data that perhaps might be available from the MLS and might not. Now, when Zillow was a broker, when Zillow was a member, the general counsel of Zillow stood up in front of the entire organization in May of 2006 and called for a boycott, saying, even though they're a member, they're going to take your data and they're going to steal it and sell it, so don't give it to them. So perhaps why they didn't have the data might be that. Now, their initial response was, okay, wow, this is a big deal. We're not going to be aggressive toward it. This is an indicator of competition where we can stay unique. Now, listing data that is available for merchandising and marketing of homes is an advertising data set. When you add solds to IDX data, when you add an AVM to IDX data, you actually aren't creating anything new in terms of innovations for a broker, participant, licensee to actually deliver something to the consumer. What you've done is you've added sold data and an AVM to advertising data. A broker or participant has always been allowed to create an opinion of value, standards of practice 11.1. If you in fact create that opinion of value, you don't have all the information necessary, you're required to disclose to your client the information that you do not have, which you may not have gotten from the MLS or might be getting other places. Now, consumers want all of the data. Practitioners might have to have access to more than what's in the MLS, and to deliver their service under which they have a duty of care, it is beyond what is IDX data. If you're going to compete in the business to serve today's consumer, you have to solve for uniqueness. You cannot solve for uniqueness with sameness that comes from a standard that is dictated by an organization. Although standards are helpful, the RISO standard is helpful, to whom is it most helpful? There is a data war going on. Who will be the custodian of our data as homeowners? Will it be a trade association? Will it be a national MLS? Will it be a group of MLSs? We don't really know. It's wonderful that we'll figure that out in the marketplace, and as those things will bubble up from competitors trying to serve consumers in this complex day where data is everywhere, when authentication can come from your phone. I would love for NARD actually to change some of the rules after the consent decree is over, because they can't right now. I have to keep a password for 6 months from someone when they formed a password, when they might want to change their password once a week or do it with a thumbprint on their phone. We look at the internet through our phones, and all the data needs to be there. Whoever the property is for sale from, wherever that property might be within a targeted geography, the technology will deliver it. There's $1 billion of innovative capital looking for a place to solve consumer needs. And I see MLSs doing wonderful things across this country, and the groups meeting together to figure out how to do that for the consumer. But unfortunately, the MLS's customer is not the consumer, and that's okay. They're owned by associations, they're owned by brokers. The only person who has the consumer, us as buyers and sellers, as the #1 customer to serve is the licensee practitioner in the state under the law that has a duty of care that's way above this data.
And Ralph, I want to ask you to comment on one of the points that Brian brought up, specifically on the RISO standards. The new NAR CEO, I think, recently sent out a letter saying that they would start enforcing compliance with RISO. I guess the question is, what do you think that compliance will look like, and why do you think it took until now for that to start?
Well, most of the MLSs came in compliance with the requirement of complying with the data dictionary and having an API. Recently, we identified roughly 100 MLSs that had not. We reached out to them. Most of them had not done so because it cost money to do so, and most of the non-compliant ones were small. I'll just sort of say gently unsophisticated MLSs who just sort of hadn't got to do that or hadn't identified the resources. But we've worked with them, we've encouraged them. I just checked the other day and we're down to something like under 20 or so MLSs that have not come into compliance with those standards. So it's a work in progress, but it's nearly complete. And again, as Brian referenced, those are the MLSs that are associated with realtor associations. Independent MLSs are free to do whatever they choose to do.
But why now? I guess the question is, why is this action happening now?
Again, it came to our attention that they hadn't all, had a complete set of MLSs come into compliance. So we're encouraging them to come into compliance as they're required to do under our policy. I
guess what I mean by that is it seemed to have been documented before that was an issue. It didn't seem like it was a kind of a new knowledge.
It's not as a result of any crisis. It takes time. As I said, it takes resources. Small MLSs typically run on a very bare bones kind of budget because their job is to serve their customers, their brokers. So they're not making big profits. They don't have a lot of extra money to spend on mandates like this, even though it's in the interest of the brokers. And so they've made progress, and we're almost there.
Well, so an open question.
Something more sinister than that.
No, I don't mean to suggest it's sinister. I'm just asking if there was anything that was motivating it. I guess an open question for the panel. We're talking about these small MLSs that aren't doing it because of the fact they're small and sophisticated, which is a reasonable reason organizations don't do things all the time. But is that a fundamental problem with the industry, that we have this kind of fragmentation? Most people, when they go online and they're going to shop, they're not thinking of going to Amazon or thinking they have to go to the Amazon of Suffolk County, whatever. They're just going to a national system, and that's what technology generally works really well when you scale up and you have national systems. How do we get to a nationally functional system if we have such fragmentation in the industry? Is that a problem in and of itself?
Well, I think we've seen over the last couple of years, and Brian's maybe closer to this than I am, a real move toward consolidation of MLSs. So the number of MLSs has dropped substantially. Large regionals are forming, but real estate, by its very nature, is a very localized business, and so these MLSs formed in local markets, and brokers that work together for the reasons Brian suggested. One broker makes an offer of cooperation compensation to assist in a transaction with brokers he knew or he or she knew to serve their customers. So it takes time for those sort of fractional and factionalized markets to come together in a more efficient way. There's certainly a clear trend toward that happening.
It's also true that, the way it is now, there are all these independent points of economic decision making. You've got 700 some MLSs. As soon as you say, let's create one MLS, one national MLS, let's say, you have one independent point of economic decision making. And that's not the sort of thing, I'm not an antitrust guy, but that's not the sort of thing the antitrust laws generally encourage, right? We don't want to roll up independent economic decision making and replace it with one entity making decisions for everyone. That's usually not cool.
But it's actually interesting to me that this is one of those areas where, and it might be because they're more complementary than competitive, different MLSs, that consolidated MLSs, larger MLSs is actually a good thing. It allows brokers to be able to compete across a broader scope, not have to join several different MLSs and face the administrative costs of that. So MLS consolidation, I think, is actually probably a pro-competitive good thing from an antitrust perspective.
Well, I agree with that, and I facilitate those consolidations, so I would be inclined to agree with that. But I guess the point I'm making is that it would be unusual for antitrust regulators to say, we want to roll up these independent organizations and make them into a bigger organization. That's not something
It's not consistent with your ordinary antitrust approach to looking at different companies getting together, but this might be one of those instances where the benefits, the pro-competitive benefits that are, MLSs are already hugely pro-competitive. It would get more so if brokers were able to serve a broader area and you brought broker competitors from further away into competition.
Yep, I agree with that completely. I think although an MLS is a JV among competitors, which would ordinarily sort of make you wonder as an antitrust enforcer, we do see them as very pro-competitive. I don't think that consolidation among the MLSs necessarily carries with it the same antitrust connotation as consolidation in other industries or in other applications. It is possible that if anti-competitive behavior occurs within a more consolidated MLS, that it might have broader anti-competitive effects, and that's something that we would want to think about. But I also think, talking about sort of the efficiencies on the side of the brokers is meaningful, but I also think that there are efficiencies for consumers, and especially on the buyer side of a transaction, not sort of having to navigate the arbitrariness of what the MLS boundaries are and to be able to search in a more holistic way. And I think that increasingly, as you mentioned, Daniel, consumers are thinking about things on more of a national level, and they're looking for a single destination. And I think we, as antitrust enforcers, I think what we'd like to do is to ensure that that there isn't something interfering with the market moving towards meeting that consumer demand.
Yeah, thank you. That's really helpful. I guess one of the questions I have for the panel is, what metrics should we look for when we're talking about MLS consolidation as a sign of success? Because it seems like, for example, one metric would be lower costs. Lower costs, there's these overhead costs that are going to be the same pretty much across all these different MLSs. They're ultimately passed on to consumers that make up part of that $20,000 average selling cost. How do we measure, what should we be measuring when we're seeing consolidation? Because it's not just the number of MLSs, it's what's the output of that? How does that actually affect the market?
I can tell you one thing not to measure. So you open, and I love your research and what you do. One thing not to measure is that somehow efficiency is represented with the purpose of reducing cost. I think that cost can get reduced, and I think friction can get reduced, and satisfaction can go up, and where costs fall, especially as a broker, but intent to where they fall is where they fall. Costs are relative, and at the end there might be efficiencies that are achieved, but it might be a whole lot more expensive to deliver services. If accountability from the broker is increased dramatically, you're going to add costs there. There might be technology efficiencies, and who knows where those costs might fall, but I don't think a metric for success starts with cost, although it makes a good point if you're looking at the business from the outside.
I will say in response to that, so I think you're right. I think even thinking about it from the consumer standpoint, a reduction in search costs can be an efficiency, right? It's more efficient, it's more straightforward for me as a potential home buyer to identify a listing that I'm interested in. But I also think that it's very interesting to me that as consumers have been able to self-supply greater and greater pieces of the services that traditionally they would have been completely dependent on brokers to supply, that I don't think that we necessarily see a change in what the cost of the real estate transaction is for those consumers when they're self-supplying those services.
You mean the example of the person who just wants to pay a broker to list her home on the MLS? Because those options are available in every market now.
No, I think that's right, but or a consumer who is taking on the bulk of the searching for a home themselves. So
as a buyer.
Yes, exactly.
Okay.
It might be at the transaction level. So RESPA drives laws that at the settlement, there are settlement service providers that all have costs to get them to that moment, borne by the transaction itself. And there are marketplaces and efficiencies that would open up in dramatic ways if those marketplaces are available with a revisit to RESPA laws completely. And driving down the transaction has to do with everyone who's sitting at the table and how they got there, whether you're the mortgage or title or whatever else happens to get things there. We used to worry about couriers sending things around. Those are costs. They disappear with transfers of electronic documents signed by my thumbprint, and here they are either on a virtual table or an actual table. So maybe the cost at the settlement table, and not reduction in commissions, or it's so cheap to just find homes. It's the overall cost that we're all bearing at the settlement table. Because the perception of the consumer is, oh, there's this big commission and that agent got all that money, and we all know like that's not true. All right, so it gets split up so many ways, and there's a data industry that sits on top of what the real estate professionals do every day. Like I mentioned with CoreLogic, that data industry sits on there and thrives and waits for the curators of data to add value to what they do.
And so a big part of this is are we giving consumers choice? I want to come, Brian, you made a comment, I don't know if it was fully picked up by everyone, where you said everyone can do a listing on MLS themselves. I don't think that's true. I mean, I think Alabama, for example, has a law, and I'm happy to tweet this afterwards about the specifics of it, since I don't have it at my disposal. But you know, where they don't allow some of these fee-for-services. I know, you know,
the minimum
DOJ,
services.
the minimum service laws. And so, I mean, I thought there were a number of states that had that. You know, I know Department of Justice has published some on this, David. So I don't know if you have any of this.
Those are bad laws too. I agree that those are not good laws.
So is that an area where we have agreement that there are some of these state laws that are inherently anti-competitive?
Anti-rebate laws, I think we can agree probably on that too, that it doesn't make sense for the legislature to prevent brokers and consumers from entering into the relationships that they want to enter into.
But,
So-
you know, it's important.
Yeah, is there agreement there, or is there not? That's
Well,
right.
there are a handful of states that still have these minimum service laws, and they came into fruition, I don't know, 8 or 10 years ago. And mostly what we heard from real estate regulators was, well, we don't really have the capacity, we don't really understand these laws, we don't really have the capacity to enforce them, we're not sure what they mean. So I'm not sure how meaningful those things are. And the other thing is, if you look at what they require, it is a very, very minimal level of service. It seems like being available for a phone call, or being available to present an offer, offer of purchase to a seller when there's an offer presented. Not hard stuff to do.
Well-
Now, and admittedly, you know, they do require brokers to do something. And to that extent, you can argue that maybe they're anti-competitive for a broker who wants to do nothing more than take a fee and dump the listing into the MLS and go away. But I just don't think they're very meaningful in a real term.
Well, I mean, so when the only reason I know about it, because I was looking at an Alabama, I mean, in a specific sense, was I was looking at an Alabama brokerage firm, and you know, they had a thing on there that specifically said, if you're trying to just list your home, please note that that's illegal. If anyone's trying to sell you this service, that's illegal, and don't do it. So scaring the consumer away from these types of things. And I mean, like, where I was going with this question is, it does seem like there's general agreement that some of these, you know, the rebates are good, minimum service laws generally aren't good. And NAR as an organization is probably one of the leading, you know, political organization. I mean, it has tremendous political power, and so when there's kind of misalignment in, you know, policies, you kind of ask the question: well, is NAR backing it or not?
We don't lobby for those kinds of laws at the state level.
Mm-hmm.
It's the consumers and the real estate professionals that lobby, you know, the legislatures or the real estate commissions for those kinds of laws, and they are still in play in a handful of states.
Can I, Ralph, weren't there some local association of realtors that were in legislature supporting that kind of minimum service
It could be.
legislation?
I mean, you know, when the idea of these kinds of listings where a broker would take a listing and basically do little or nothing to service it came up, we actually had discussions with the FTC. We understood that, I mean, the instinct of some brokers was to say, no, you can't do that. We understood that we couldn't say that, MLSs couldn't say that. We talked to the FTC about that, not you, Jessica, many predecessors ago, and the FTC agreed that with us that, you know, sort of collective prohibition of those kinds of listings was inappropriate, but it was permissible to identify in the MLS listings where brokers were not going to provide any services in connection with the transaction, just so the broker on the other side of the transaction knew what to expect when he was providing a buyer in connection with the seller, so that both sides really understood what was gonna, how that transaction was gonna proceed, how it would be marketed.
And to be clear, it's to identify those
So all it did,
those
right.
listings, not to treat them any differently with respect to
Absolutely.
dissemination of the listings information.
So what kind of information should be, let's go maybe a little bit beyond some of the listing information that's in IDX. There was a flat fee broker, Charlora, in Colorado, that they tried to display compensation rates for different listings. And they immediately got a letter from their local MLS saying, no, you cannot do this, and they were forced to take it down. And their point was, general market transparency is good for users. The more you know about what you're buying, the more you know about what people are paying. That's good for users. And the MLS came back and said, that information shouldn't be out there. I think most people can see the competitive benefits of that. Brian, let me go to you on this. Is that an appropriate action for an MLS to be taking? Is that something where we might need some additional oversight on those types of policies?
I think there's some. So I want to make something clear here. The Council of Multiple Listing Services is paying my cost to be here, but what I say is not necessarily their policy, because what I'm going to say right now might not strike some MLSs as very good news. But what I would ideally like to see is that the compensation that's being offered by a listing broker to other brokers is not visible to brokers except the broker who's receiving the offer. In other words, as a listing broker, I can put my listing in the system and I can say, I'll let Bob sell it for 2.1% and I'll let Rob sell it for 3.1% because he does a better job. But I don't want Bob to know what I'm offering to Rob. And that's a competitive pricing approach, right? I mean, antitrust laws like that kind of flexibility. By publishing just one number in the MLS, I think we create a kind of pressure for the price to stay where it's at. So I'd like to see the price invisible to the brokers, except for the broker who's receiving the offer. As to what I think about the consumer seeing it, it's largely irrelevant because the brokers on both sides of the deal have the responsibility to disclose the compensation they're going to receive before the transaction closes, and they certainly find out at the time that it closes. So it's unclear to me how it affects anything from the consumer's perspective until and unless she's ready to negotiate a transaction.
But I would answer your isolated example of a flat fee broker advertising his fees or in comparison to others and getting a letter from the MLS. I think that's a result of years of us schooling brokers that it's inappropriate to talk about commission rates. And some of them understand incorrectly that that means that you can't advertise commission rates. But they've got to, I've been doing this for a long time and talking to brokers and talking to associations and talking about the risks of engaging in discussions about commissions. They understand that, and that's why they're often reluctant to advertise commission rates. But when I get those questions, I tell them that's not anti-competitive, that's pro-competitive. That's permitted as long as there's no inference that everybody charges that rate in the area when they don't. You, in fact, in your introduction talked about fixed commission rates. There's no evidence that there's any pervasive fixing of commission rates. There hasn't been a price fixing case in the real estate industry in years.
And commissions have gone down consistently for the last 25 years. They're averaging 5.25% now, which is not, maybe you think that's a lot of money, but it's 3% less than it was 4 years ago.
Well, it's interesting because that data is some of the data that people are asking for when they're saying if we had access to the MLS data, we could actually have verified analysis of these different claims, because I've seen different claims about rates going down or rates.
Dan, we have to actually distinguish something really important there. What Ralph was just talking about is gross commissions, what the seller pays the listing broker. MLSs do not have that information. We can't ask for it. Well, we could ask for it, but it would be really risky to possess it because it would enable price fixing. What I was talking about is the amount of money that the listing broker is willing to pay the cooperating broker. And the seller doesn't pay that amount, right? She might negotiate with her broker about what that amount will be to incentivize other brokers to come to the transaction. But the seller doesn't pay that amount. The listing broker pays that amount. Right. So we just don't have that. We have studies that others have done outside the MLS. And I don't have any reason to believe they're any less reliable than any of the data that's in the report you guys published in the fall, for example. So, it's at least based on gathering statistical information from a large subset of, or a large set of transaction data.
That's replicable. For example, there's nothing I report that isn't replicable information or citable information.
Well, we could talk about that in a whole other hour-and-a-half session. So that's fine.
Let me raise another issue that I want to make sure we address, and that's pocket listings. One potential avenue away from, or whether you see it as moving away from MLSs or creating more competition, is pocket listings. So, Zillow had a coming soon feature. I don't know if that's actually still current. But the idea is that a broker could list a home on a site and say it's coming soon. So it's before they put in the MLS, and it's a way to market. Now it could be a way just to market the home and say get ready for your bids. But in a seller's market, it can obviously be a way of selling directly without having to pay a commission on there. FC Tucker, which is a Indianapolis-based real estate brokerage, warned its agents that they would be subject to a $600 fine if they use this feature. So they were telling all their agents, don't go on Zillow and put that out there, or you're going to be fined. Based on, they were saying it was based on Indiana licensing law. I know FTC's looked at a lot of different licensing impacts there, but what was I think really interesting about it is it wasn't just Indiana licensing law, but it was then the compliance with the law was based on the rules that were set by the local real estate board. So the state law says you have to comply with what the local board says, and then of course the local board's made up of a lot of these agents that are part of this brokerage firm. So I guess the question is, should there be restrictions on alternatives to MLSs? Is that anti-competitive, and what kind of metrics might we look at to see the impact on consumers there? Maybe Jess, I'll start with you.
Yeah, and Brian's disclaimer reminded me that I should have started with one of my own, which is that my opinions as voiced today are mine and not those of the Commission, of the Bureau of Competition, or of any commissioner. I think that the question of pocket listings is one that we're very interested in exploring in the workshop. We'd like to understand sort of what the implications are. I think that they are a newer phenomenon and represent a development in the industry since our last in-depth look at it. As far as the licensing laws and the restrictions on alternatives to MLSs, I think another thing that we'd like to explore is the impact of any state or local regulation or other collective activity by private actors that is potentially changing what competition looks like in the residential real estate brokerage market. And so we invite your comments on those. We are always happy to be invited to offer advocacy positions on things like that. And so that's one of the things that FTC is always interested in hearing from the public on. I think that, in each of these cases, we look at the individual facts on the ground. So without opining on the Indiana case in particular, or actually even on the Trello case, as far as limitations on, truthful, non-deceptive information being disseminated, I think that that's something that requires a much closer look, and that's something that, as we hear from folks about potential issues in local real estate markets, we're more than happy to look at, just as we do with other licensing issues. Mm-hmm.
And Daniel, I mean, with regard to pocket listings, I'll be clear, I don't think any MLS really likes them. That shouldn't be a surprise to anyone if you want to operate a comprehensive database of what's available on the listing market. But I don't know of an MLS that doesn't pursue what I would call the standard NAR approach to this, which is to say, we can't stop you from having pocket listings. However, if you sign a listing agreement with a seller and it's not going in MLS, you have to submit a form to us so that we know that you have the seller's permission not to put it in MLS. And if you do that, the MLS is done with it. I don't know about this Indiana situation. I mean, I've never heard of a state regulator adopting the MLS's rules. But even if it had, the MLS's rules would be, send us a piece of paper that tells us the seller made this decision. If the seller made the decision, we're done with it. And now the state's regulations, on the other hand, the tricky part is if you put a listing on Zillow as coming soon, is that advertising the listing? Because in most states, under the law, in order to advertise a seller's listing, you have to have a signed listing agreement. And it's the signed listing agreement that triggers the requirement to send the paperwork to the MLS. And so as long as the broker is getting the seller to say, don't put it on MLS, and is sharing that information with the MLS, I don't know of an MLS that's going to go after them for marketing that listing thereafter. And if you haven't offered a counterexample, I don't know of any from the news. I mean, I do read the news about that sort of thing.
So it wasn't an MLS. Again, it wasn't the MLS that went after them. It was the brokerage, FC Tucker, that threatened its agents with a $600.
Well, so what a brokerage decides to do with its own business is that broker's business, right? I mean, we're not telling brokers what they can and can't do.
Under a state law.
I don't know anything about that state law.
I'll tweet this link to
Yeah, please do.
I might be able to help here, Daniel. Sure. I'm sorry to interrupt you.
No, go ahead.
Well, there's a trend here to say who paid for whom to come here and who they represent. I'd like to say that I didn't no one paid for me, no one's paying me to be here, and my views are my own, and I came from only 70 miles away, so it wasn't that expensive. But with that, for everyone in the room, a pocket listing is often is not really well defined, but an agent will take a listing, if you will, and advertise it before it goes into the MLS. And pocket listings start actually in the pocket of the owner, because they already may have started talking about their houses for sale and they may not have listed it just yet. And in the process of actually getting it sold, depending on the dynamic that goes on and the market conditions, it might be desirable for someone to always have a pocket listing. If your property is owned by an LLC and you are worth hundreds of millions of dollars, that house may never make it in the MLS, and it might always be a, quote, pocket listing. Any broker who has a policy with their agents under any law can fine their agents anything for not following that policy. The broker's liable for the acts of their agents. Their agents, there's a low bar of entry and a high level of accountability that needs to happen with brokers. And I'm not suggesting we raise the bar to the agent. My mother, when she got her license in '74, and I saw those MLS books, the bigger the book, the better for buyers. I learned that earlier. So if the bigger the book is better for buyers, you want that listing in there. You're going to do it quickly. If it's better for sellers and you might make more money is a question, that is the broker's decision. It is the seller's decision 100%. I agree with Brian. Whether it's, we are a self-regulated industry. Those on the real estate commissions are members of the organizations writing these laws. The brokers who run their organizations across this country, there are tens or maybe 100,000 of them that might have these 1.2 million agents. Those are the competitors, and they are the ones that can make policy for their agents. Should be no question about their ability to manage their agents underneath of them that create the liability for them as the broker.
And if I can just to add to Brian's point, MLSs do not, their pocket listings are generally disfavored because they're sort of philosophically inconsistent with the notion of MLSs as being a device by which brokers cooperate in the sale of transactions. But MLSs understand that they can't and shouldn't do anything to prevent pocket listings. They do ask brokers to notify them when they have a pocket listing, and the sole reason for that is so when other brokers see a sign on that property and see it's for sale, but they can't find it in the MLS, they call the MLS and ask what's going on. The MLS knows because the listing broker has told them it's a pocket listing, and they tell the broker that, and they have an answer to that question. That's the only reason.
Well, I think the issue of pocket listings gets to, I think, this kind of bigger question of, should we be talking about open access to listing data, whether it's a pocket listing, whether it's an MLS database. The point is, as you said, I mean, the average consumer, they walk by, they see a house for sale, they just want to know where to find it. And most sellers, they think, the more there's listings out there, the better it is for them. That's generally the way markets work. So is there ever really a reason to hold back the data on, listings? Should we just have open access to it? So, if you want to have a pocket listing, but if you want to have only pocket listings, you can share that on your site. If you want to aggregate it from the MLS and these other things, you can do that. And give, again, going back to this idea of choice, give consumers the choice and give the businesses the choice to present all these different models, and then we see which one works best.
I think that's what we have now. Brokers have the choice to display their listings on any website that they want, and you can open any browser that you want, and you can see, the entire market or virtually the entire market of real estate listings, except where a broker has chosen in his and his seller's independent interest not to make that listing available on all sites or on some sites or whatever they decide. And if a seller doesn't like that broker's policies on how they distribute the listing data about that property, they can choose a different broker that has a different practice.
David.
And the competitive incentive for brokers to have listings available as widely as possible is massive. I mean, it's competing for a listing. It'd be pretty easy to say, don't go to the guy down the street because he's not putting his listings on Zillow or wherever. Mm-hmm. And so as long as brokers are independently making a decision, if a broker decides that it's in, he's got a competitive strategy based on this, and it's consistent with the obligations to the seller, it should be left to the broker to make that decision. But because the competitive incentives are so strong for brokers to widely disseminate their listings to the extent that you start to see a lot of withholding of listings, from public sites. I would think that my former colleagues at the DOJ and Jess at the FTC might start to wonder whether there's something else going on there, and want to look more closely at that. But does there need to be a mandated public access? I think that would also create issues of their own.
And there's something else going on, you mean collective activity to withhold? I mean, everybody understands that that's illegal.
Right. I think that's right. I mean, keep in mind, the FTC and the DOJ didn't force music publishers to create the BMI and ASCAP, right? You were skeptical of the creation of those things, because if you start consolidating all this listing data in one place and you say to sellers, you have no choice, your listing has to go here, and you say to brokers, you have no choice, your listing has to go here, again, you're eliminating those independent centers of economic decision making that exists in every seller and every broker right now. The switching costs to move from one broker to another are trivial. So if a seller doesn't like what she's getting, she goes down the street, or more likely across the street to another brokerage firm, right? You mentioned in your report, Edina Realty withholding listings from Zillow. Well, it made sense for them to do so because they had consolidated access to all their listings, right? And they wanted to get something out of Zillow instead of just having to pay Zillow money every month for displaying their listings. According to Zillow's own estimates, more than $1 out of every $100 of commissions paid to residential brokers are currently now going to Zillow. Now, that's a kind of not disintermediation, what you were talking about with the travel agents. It's a kind of super intermediation, right? Here's someone who's inserting themselves into the stream of the transaction and is not reducing any costs and is not eliminating anyone participating in the transaction. So for the broker to say, I'm skeptical about wanting to do that, if a new big if a broker said, well, I want to be in Zillow, but I don't want to be in Trulia because I think Trulia is, crap and it's got smaller market share. I'm not saying that, by the way. Trulia is just fine. But if a broker wanted to do that, it would be nice if the broker could say, I want to do that, because the broker's got an independent economic interest that she might act on. And in response to, particularly to what Dave just said, if a lot of brokers chose not to send their data to Trulia, that doesn't necessarily mean that they're colluding. It may just mean that it's a really crap deal, and a lot of brokers don't want to buy it. And so that's that. I mean, if the seller and the broker are not interested in sending the data somewhere, it's unclear to me why anyone else should be telling them, should be intervening, to the extent that it means that you're removing that independent economic decision-making authority from those folks. That's just not what our antitrust policies are designed to do. Never have been, never will be.
There's a fact that's missing here that's super important, and I'll respect Brian, where the broker's listing upon, so the agent of the broker is curating, and then there's a moment where they click submit. And depending on the MLS, the rule of authorship and copyright might transfer at that moment. So the broker may have owned it for fractions of seconds, and then the competitive process, the data industry that then lives after that click, then creates a different level of competitiveness within the brokerage industry, within the data industry. Where does the MLS take that data? How do they monetize that data? What becomes competition in the data world between the sale of that data? Do MLSs then decide, well, I'm going to send data to Zillow or to any other portal, and I'm also sending it to Realtor.com, and where does the money flow on the transfer of ownership? And are all brokers aware of that? If you introduce a new way of ownership transfer, you've already got listings in the MLS, a new policy comes along and says, from here forward, you transfer authorship. You brought up the music industry. What happens in the music industry is the writer of the song and the creator of the music gives up at that moment their ownership and claim to anything that happens to that which they just created for them and their seller and their business. And it goes into a whole nother world of the data industry that lives on top of what's curated by brokers and agents in their service to buyers and sellers. And I don't think most brokers actually know that that's going on. Well, it's a completely different industry.
In part because it's not. I mean, Ralph and his folks would come after us. If you submit your listings to an MLS, at least an NAR affiliated one, certainly to any of the ones that I've ever advised, you submit your listing to them, you submit a variety of things, sometimes photographs, sometimes textual descriptions of the property. The MLSs do not claim copyright in those without the listing broker consenting to that, and they have a choice not to consent to it, because otherwise NAR's policy goons will come after you and they won't make your life very pleasant.
Well, then I'll bring the stack of emails that come from MLSs that when you supply your listing data, a new policy is introduced where authorship transfers at the moment, and you already have some listings in there. In order to put your listing in tomorrow compared to yesterday, policy changed and authorship transferred.
Ben, those are recent emails, and those relate to transfer of the ownership in the compilation copyright, which is the organization or arrangement of the data, not in the components.
MLS has already owned that. A broker doesn't have even that to give up, so there wouldn't be a policy that they would have to agree.
Yeah, it is a policy they have to agree to because they need to document to the Copyright Office that they're getting the consent of the brokers to own the compilation. That's the only reason those changes have happened.
Once,
why don't we come back to the copyright issue, because well, also ITIF, I'll tweet this out later. We've done a number of reports on BMI and ASCAP and our own model for how to solve that issue. So we'll come back to that. I want to open it up to questions from the audience as well. Anyone who's watching on Twitter, again, use the hashtag ITIF Real Estate, submit it there, and we'll read the question out loud. But anyone in the room, if you just raise your hand, we have a mic that will come around. If you can just introduce yourself and any affiliation, we'll go from there. Yeah, we have one right up here.
Derek Eisenberg, Continental Real Estate. I'm a flat fee broker in 24 states, and I just wanted to point out a few things that were said. First of all, as to pocket listings, you cannot opt out without a cost in every market. For example, in my home MLS in New Jersey, it's a $60 fee if you do a pocket listing. So there's a penalty for it. As to filtering limited service listings, Cape May County MLS incorporates limited service into the status, and it can be isolated so that a broker looking for homes for his client can intentionally avoid limited service listings. That should not be allowed under any circumstances, but it is. As to regulators not enforcing the minimum level of service laws that Mr. Holman said, that is totally untrue. They torture us. In fact, in Colorado, it's very, very difficult to be a flat fee broker. That's one reason that we've avoided that state. Alabama, we just recently got licensed in. We'll see what happens down there. Illinois has contacted me with charges of violating the minimum level of service law. They are very, very aware, and they enforce them to a T. And by the way, those laws, they're not prompted by consumers and realtor organizations. They're only prompted by realtor organizations. Consumers don't know a thing about it. They're not behind it. They're anti-competitive laws to protect the status quo. And I might just add to the point that we do offer full service. We offer a menu of services. In fact, we'd rather get the higher service listings because we make more money on them. But we give the consumer the choice, and because some consumers don't want that additional service, we're burdened with these restrictive laws in a handful of states, and it's just terrible, and something should be done about it.
Thank you. Any reactions?
I'll just say I hear what you're saying about the enforceability or the enforcement of those minimum service laws, and I don't think that from our standpoint, looking at them as antitrust enforcers, that we think that's any justification for them being in the books. I think they can have a chilling effect on competition if they're anti-competitive laws, irrespective of whether they are easily enforced once enacted. And you'll see the FTC and DOJ jointly and separately, I think, did quite a bit of advocacy around laws like that. A lot of that coincided with our last workshop. It was around that same time frame. But again, I'll just reiterate that that we are always interested in understanding where there are opportunities for advocacy to ensure that competition isn't impeded.
You need a workaround for state action.
Other questions? Back.
Hi, we have a question here from Twitter from Michael Werzer. Michael asks, in a hypothetical world of open listings, would the seller have any control over what sites could advertise their house for sale?
Well, since I'm the one that brought it up, maybe I'll answer that. I mean, it would obviously depend on how we do it, but the general way of looking at open access, which is what I described it as, is that the information on listings would be, there would be a certain amount of information that would be defined as being available and open to the public. It could be what is currently in IDX, which is what's on the sites, but maybe without all the restrictions that go along with the IDX data right now. It could also involve other information as well. There might be some limitations, for example, photographs, which are generally protected by copyright. Maybe you wouldn't include that. But all the factual information about a listing would be included. That factual information would not, the seller would not have a control on where it goes, just like, when, certain factual information about, phone numbers is published, the publisher of that phone number doesn't have any control over how else that factual information is distributed. What I think is really interesting is that, when I've talked to different brokers about this and real estate agents, a lot of the concerns they have around open access to real estate listings data is very similar to the objections we hear around open data in general when we talk to government agencies. So, lots of government agencies have adopted open data requirements, and, one of the first objections they usually have is, well, this information might be taken out of context, people won't understand it. Recently, CMS, Center for Medicaid and Medicare, services, they created requirements for open data around doctors' fees and what they were paying. And, all the doctors' groups pushed back, saying, no, we don't want this information out there. Patients can't understand it. Reporters don't understand it. And they went ahead with these rules, but at the end of the day, now we're seeing lots of information about some really bad stuff that was happening. There were doctors, we're talking about the opioid crisis, and doctors that were basically being involved in pill mills and these kind of things. So that kind of transparency was actually very useful. And we often hear objections to open access that don't actually, those concerns don't really play out in practice once they're pushed through.
Could I add on to that? I think it's an interesting possibility. I mean, you have to work out a lot of problems about like who's going to be responsible for maintaining it and what form it's going to take and what kind of power is that entity going to have, because now you've concentrated a whole bunch of stuff and taken away a lot of independent economic decision making and positioned in another person. But I think there's a quote I'd like to read you. It says, "The possession of large amounts of data by itself does not usually create a large barrier to entry," which is what we're talking about with these technology companies. "Even if it did, competition policy should not seek to create a level playing field for all companies, especially when companies benefit from advantages that they created with their own resources in which others are free to emulate." So what I'm getting at with that, by the way, that's a quote from the report that you guys did last March when you were saying we shouldn't worry about competition issues with big internet companies. Real estate brokers we got to worry about, but not the big internet companies.
We talk about both of those in both reports.
Yeah, well, anyway, the point I'm trying to get at here is that open access sounds great in the government context because, after all, I'm already paying for all the data the government collects, right, as a consumer. So I might want to have access to that. But it's the seller who's paying for the data that the broker has about the seller's listing. So it seems to me if you want listing data from sellers and brokers, you should ask them for it. And if they're willing to give it to you, I don't know an MLS in the room that's going to stop you from doing that. And many of them will facilitate that for you. I mean, I think you've used the example of Mint in the past, right? That's not really analogous because for Mint to work, the consumer has to say to their bank, yeah, let Mint have my data. But open access is really forced access. It's really telling sellers who already have lots of choices in this market and lots of data, it's telling them, oh, we're going to put your stuff wherever we want. And you don't get a choice. Well, that's great if you're an internet technology company, maybe, but it's unclear to me whether you're not just going to be a super intermediator, and it's not clear to me why we should take that control away from the seller and the broker. I think Ben makes a good point where it's not just the broker's decision, right? Because the broker has a fiduciary duty to the seller. And so there's probably under most states' laws. So there's a relationship there. But we know that nobody outside of those two has the right to decide that, right? Whatever you might think about who inside those two has the right to decide, nobody outside does have the right to demand that information. It'd be just like me saying to y'all, well, I would like open access to your wallets. And if you said to me no, I would argue that that's unreasonable or not justified. Well, that's baloney. You've got valuable things in your wallets. Brokers have valuable things in their databases, and they don't want to give access to them.
I think there's two interesting questions here. One is, whose data is it really? Because you kind of imply it's the customer's data, and then you kind of said, well, it's the broker's data.
What I'm telling you is that it's either both of theirs or one of theirs, but it's not yours. It's not Zillow's. It's not Realtor.com's. It's not Microsoft's. Mm-hmm. Nobody can make a claim to it except the broker and the seller. And so ask the broker or the seller for the data. If they say yes, you can have it.
So I think the comparison here, if I can respond, Ralph, I'll go to you, is that so the FTC has had a number of instances where basically the question is are the incentives aligned correctly, and do consumers actually have power? And so, the comparisons would be, like with, contact lenses or pet medication, where, often consumers have access to their information. So if you're getting your contact lens prescription, you have a right to have this contact lens prescription and take it from your optometrist and go buy contact lenses online.
If you're the consumer, if you're the consumer to direct your own information, right? We're not arguing about that.
Right. And if you're the consumer, you have the right to, get your prescription from your vet and go buy it online.
But to be clear, lens crafters can't go to your eye doctor and say, "Give me all the prescriptions of all your patients."
And that's not the point I'm making.
Well, the point I'm making is that's what you're saying when you're saying the seller and the listing broker don't get to decide where the listing data goes.
Right. And what I'm saying is that the reason I think this situation, there's a parallel here, is because consumers generally aren't very empowered in these interactions. And if you don't have a default of openness, which is what we're talking about here, there could be lots of conversations about where we draw the lines and if you allow consumers to opt out. The question is, what's the default going to be? And how are you going to ensure that consumers' interests are actually represented? If we think consumers' interests are generally represented by that information being out there, then we need to facilitate that through policy. And that's what we're doing in these other areas, like pet medicine and like your contact lenses.
With the consumer's consent. With the consent of the consumer about whom the
relation... But without the consent of the doctors, without the consent of the vets, who have traditionally resisted. And my point is, in this case, I think the real estate agents are more like the vets and the optometrists who would resist getting that information out there.
And we would only know about that if consumers were upset that it's not getting out there, like we were when Wells Fargo wouldn't let Mint get access to my Wells Fargo accounts, for example. Now I can. But the point is that the consumer initiated that distribution of data. Mint offered the consumer something in return. So my advice, if you're an internet technology company, you want to make it in real estate, is to go out to consumers and offer them something of value in return for their real estate listing information. And if they want you to have it, my guess is their broker will send it to you. And if your broker doesn't send it to you at that point, well, then the consumer should complain and maybe complain to you folks.
Choose another broker who does.
Or choose another broker who does.
I mean, in this hypothetical world of open access, it would be exactly as it is now. Is the seller has the right to say, you may send or you should send my listing data to certain aggregators or not. And if the broker says, I'm not going to send it to a particular aggregator and the consumer doesn't like it, he can choose another broker. I think the worlds are identical as they are now. A broker's got an interest, though. I mean, these are brokerage businesses. They're in it as a business to try to earn a living. And so if supplying the data, the listings to a particular site is in contravention of that broker's interest, he or she's not going to want to do that. But he's got to balance the consumer's interest and the consumer's desire to send it to that site against and choose which is the most effective strategy for him. But there's so many brokers out there, they'll all choose different strategies, and consumers can choose the ones they want.
Well, but that's my point.
Empowered consumers, then the FTC and the Department of Justice can do what they've done in other industries and help consumers understand what their choices are.
And they've also gone further. I mean, Congress has gone further and created laws requiring that information to be available, and that's where I think, just like you have your choice between vets, you don't make your decision about which vet to go to based on which one it gives you the least hassle about taking your prescription online. At least that's not the decision most people make in the moment, and that's what the evidence has shown.
Well, but open access is different than, if Congress wants to pass a law saying a broker has to inform a seller where his listing is going to be distributed, that's far different than requiring brokers to distribute their listings everywhere and anywhere.
Or even saying the broker has to disclose to the seller that she may require that her listing be distributed wherever she wants it, and the broker will comply with that.
We also have to take into account the extent to which distributing the listing to certain websites is actually in contravention of the broker's interest, such that he may choose not to, he may find it not profitable to continue to take those kinds of listings.
And he may lose out depending on the delivery of the information. So openness is strong, seller and buyer choice through their broker strong, but at the end, who is configuring what type of system for whom? An open API, although a fantastic idea, doesn't actually serve what a broker needs to deliver services over the internet. A download of the data that's not any different than what some other organization can do to download. An open API that might just be designed for the industry, revolutionary for the MLS, is not revolutionary for the broker serving the client. It might be revolutionary for the data industry, but if a broker is going to serve their client, a download of the data to make uniqueness, not sameness from advertising, methodologies in IDX, but to create uniqueness. The Bible of strategy in the world of competitiveness, Michael Porter's book, every B school has it. Anybody building uniqueness is going to differentiate, and you have to do that with a downloaded data set to decide to whom it is open. Our public records are open today. Zillow was built on the public record data set. Anybody with money, innovation, and smarts can buy the data from CoreLogic, build a database, and do it all day long, but you have to compete and openly. But that data by a broker, they've got to download it. It can't just be an open data.
And you just mentioned having to buy the data from CoreLogic, which isn't cheap and comes with restrictions, right?
It's less than $2 million.
Right.
We'll do one last quick question and one last quick response.
So, Rob Hahn, 70S Associates. I have a comment and then a related suggestion for you all, and then a question. The comment is, you guys are talking about RISO standards and that the listing data is available out there. I completely agree with that. But the difficulty of innovators in the real estate industry today is actually not the listing data, it's permissioning and it's the business rules. As the various 600, 700 different business rules per each MLS in the permissioning process. And RISO that hasn't yet gotten, I know they're working on it, but they haven't yet gotten to it. So a suggestion then is this. One of the issues, as we all know in the real estate industry, the internal politics of getting something like this done is immense. M&A, consolidation, data sharing discussions go on for 15 years. This might just be an area where NAR, CMLS, various MLSs potentially seek partnership with policymakers and see if there's some way that they can partner on something like that so it doesn't take 20 years to deal with permissioning and business rules at the local level. That's just a suggestion. The question now is this. Brian mentioned, and I think this is exactly right, that the antitrust approach typically is not make them bigger, right? But it seems to me there's an alternative approach which was brought up in 2006 during the congressional hearings, which was to make the MLS into a public utility. Have things changed enough between now and then? Brian's laughing because he knows. Have things changed enough where that's still completely off the table? Is that not something to be considered? Especially considering that, like Ben said, the public data is all public and open, meaning it's hard for me as a homeowner to say, I totally control the marketing of my house. The minute that it's sold, though, it goes into tax records and now it's available to everybody. So it's just a question for the board. Is a sort of more regulated, we're going to give you a monopoly, we're going to do these things, we're just going to regulate you as a utility. Is that totally off the table?
I think that was for you, Jess.
I'm curious to see what the reactions are from the others on the panel. So I will tell you that at the FTC, I think of us as a law enforcement agency more than a policy-making body, right? So it's hard for me to imagine a scenario in which we regulate the MLS as a public utility. I think that, when you look at some of the MLS cases, it's fair to say that it's seen as essential to competing in the brokerage industry in a localized market. And I think that's about as close as I see us being able to advance the ball in that direction. I do think that if there was sort of industry interest in treating it that way, that would be something that we'd be very interested in understanding and exploring, and understanding how that would play out for consumers. But it's not something that I see a clear path to from a policy perspective, at least coming from us. I think there's always the question of whether antitrust is the best tool to solve any given policy problem, and sometimes it's not. I like to think antitrust is always the answer, but that's just not the way it is.
Great. Well, I think we're going to have to stop there just because we're at time. Please join me in thanking our panelists. I think this was a fantastic conversation. I certainly look forward to continuing this with the FTC work with DOJ.
Thank you, Daniel.
Thank you.
Can I just make one more plug before everyone goes? Please do visit our website, look at our events page. There are specific questions where we're seeking public comment, and we would love to hear from you. You can also email us at realestateworkshop@ftc.gov.
Thank you.
Thanks.
Thanks, Ralph.